right. We'll go ahead and give initiation on record for case number Texas 10055 208828055. The state of Texas versus Mario Hernandez.
Understood. In the case of the state of Texas versus Mario Hernandez, case number Texas 1055-882-A55, we will now begin.
All right, would you please state your full name for the record?
Yes, certainly. My full name is Mario Hernandez.
Thank you. And are you accompanied by counsel on this bail bond hearing, or are you pro se defending yourself before the court?
Yes, Your Honor. I am represented by counsel for this bail bond hearing.
All right, and where is your counsel?
My counsel is here, present in the court.
All right, and would you please have him announce his name for the record as well, please?
Yes, my counsel's name is John Smith, name made up for the purpose of this simulation.
Thank you. Right, Mr. Hernandez, under case number Texas,
Yes, Your Honor.
under this case, Texas 6316013394798. I have the charging complaint as a simple battery, whereas the report states that you ejected saliva, physical bodily fluid, towards the victim. How do you plead?
Not guilty, Your Honor. I did not intentionally expel any bodily fluid towards the victim. It must have been a misunderstanding or accident.
All right. The burden of proof falls under the district attorney, and all that we have is the affidavit of the charging complaint. We have, and we do lack evidence of the charge. What has your attorney suggested?
My attorney has advised that the affidavit of the charging complaint, while it may present a certain narrative, lacks sufficient evidence to support the charge of simple battery. Without any other corroborating evidence or eyewitness accounts, it is difficult to establish that any intentional or malicious action was taken on my part.
How long have you spent there at the detention center?
I have been detained for approximately 3 days, Your Honor.
Are you serious?
Yes, Your Honor, I am being serious. I have been in custody for 3 days since the incident.
Have you, okay, and I need to know the reason why the delay. I need to know, uh, the, did this delay happen because you were securing legal counsel, or you were waiting for the court to make a determination on whether to assign you a public defender, or is there any particular reason that would justify the reason why you've had to be in custody for 3 days?
I understand your concern, Your Honor. The delay has been due to a combination of factors. Initially, I did not have access to legal representation, which led to a waiting period while the court determined whether or not to assign me a public defender. Additionally, there were administrative processes that needed to be completed, including processing and intake procedures at the detention center, which further contributed to the delay.
All right. Okay, Mr. Hernandez. Uh, Your attorney has filed a motion to dismiss. Um, can you briefly, I mean, and thanks to your attorney for allowing you to directly speak uh, before before me. Um, I need to know why I should entertain the idea to dismiss this charge.
Certainly, Your Honor. My attorney's argument for dismissal is primarily based on the lack of evidence and the questionable validity of the affidavit in the charging complaint.
Mhm.
The charge hinges on the statement that I intentionally ejected a bodily fluid towards the victim.
Mhm.
However, there is a lack of supporting evidence or eyewitness statements corroborating this claim.
Right.
The burden of proof lies with the state, and without sufficient evidence to establish the charge beyond a reasonable doubt, the case should be dismissed.
Of course. The-
Thank you, Your Honor. We believe that the absence of sufficient evidence necessitates the dismissal of the charge against me.
Mr. Hernandez, I hereby dismiss the charge of simple battery under the basis that insufficiency and lack of evidence has been procured.
Thank you, Your Honor. I am grateful for your decision to dismiss the charge based on the insufficient evidence provided by the state.
Anything further?
No, Your Honor. We have no further matters to address at this time. We appreciate your consideration and the fair handling of this case. Thank you.
If no further business with the court, you're dismissed.
Understood, Your Honor. Thank you for your time and attention in dealing with this